Thank you so much. It's always a privilege to go after someone who is as engaging and provocative and brilliant as Jack Balkin. So it's great to be here. Thank you so much for having me on this glorious day in this beautiful town. I've only been here for ski season, so it's lovely to see the sunshine. Although if you want to invite me back during ski season, that's pretty cool with me too. So thank you, Dr. Bibby, for presiding over this wonderful conference. Thank you to Thomas. I don't know if he's here. Yes, thank you. And to all the fellows and the volunteers for all of your hard work and for making things run so smoothly. You are sometimes invisible hands that are making everything work well behind the scenes. So I just want to make sure that I thank you publicly. And I think I might have I tried my best to convince some of you to go to law school during the times you've been shuttling us around. And so for that, I apologize in advance for your student loan debt. But it's great to be here also because I graduated from Claremont McKenna College undergrad, and I took con law from none other than Ralph Rossum. And I went to Yale for law school, and I took con law from none other than Akhil Amar. So I sort of feel like I'm here with my mentors, and it's a really great privilege. As you might have guessed from the description of my organization, Constitutional Accountability Center, we do what we call progressive originalism. Now, I sort of don't like that label for a variety of reasons. One is that we're not doing a different kind of originalism. We're looking at the text and history of the Constitution, the same text and history of the Constitution that conservatives look at. But when we do, we find it points in a progressive direction. And so that's why I put that label on it, because previously originalism has been associated purely with sort of a conservative outlook, conservative results. So what I want to talk about today, which might not be surprising given where I work, is Scalia's legacy and his liberal legacy, which might be surprising to some, and probably be surprising to Justice Scalia himself. But what I mean by that is that because he was such a powerful presence, because he spoke so well and so passionately and compellingly about originalism, both to the public and in his opinions, it spurred those of us who pay attention to, whether in academia, grapple with, litigate in the Supreme Court, to really confront his originalism and take a look at the Constitution's text and history. And he did that for progressives. So progressives, as well as conservatives, started to look at the Constitution's text and history, and we liked what we found there. And for that, I think Justice Scalia doesn't get all of the credit, but he certainly gets some, which he might not be happy to take. But for that, I am grateful. He certainly was part of the inspiration behind the Constitutional Accountability Center and the work that we do. So when progressives started to look at the Constitution's text and history in the same way that a conservative originalist would, we had academics like Akhil Amar really bring out the document, bring out the history behind it. Jack Balkin, Jim Ryan, many others contributed to this scholarship that showed that we had a Constitution that, when it was written by revolutionaries in the 18th century, was not just about limiting government, which is often portrayed as, but was about creating a federal government that could provide national solutions to national problems, a reaction against the failed, dysfunctional Articles of Confederation, which didn't provide that kind of federal government. And so, while yes, the founders were concerned about keeping the government small enough so that it wouldn't be tyrannical and overbearing, they also wanted to make sure that the federal government could actually work, could provide, as I said, national solutions to national problems that our new country would face. They also did not want to keep the Constitution purely as it was written in the 18th century. That's why they had the wisdom to write in the amendment process, to allow, as Professor Amar said this morning, each successive generation to renew the Constitution. And we did, in extremely powerful ways. And the progressive originalists who did this scholarship elucidated the text and history behind the whole Constitution. They looked at the Reconstruction Amendments. They looked at how the bloodshed of the Civil War was redeemed when we passed the Reconstruction Amendments that removed the stain of slavery from the Constitution in the 13th Amendment, that put the Declaration of independence into the Constitution for the first time in the 14th Amendment by actually declaring in the words of the Constitution that all are equal, that all deserve liberty. And the 15th Amendment, which made sure that the newly freed slaves who were given equal citizenship at birth in the 14th Amendment could also have a voice in their democracy, and the 15th Amendment guaranteed the right to vote free from racial discrimination. We saw, again, going further, that people who fought the most important social and political movements in our nation's history could write in a more inclusive, progressive constitution with the 16th Amendment, which allowed the federal government, through the progressive movement, to have a national tax. The 17th Amendment, which allowed the direct election of senators. The progressive movement fought for these because they thought it made the federal government more effective and more responsive to the people. Then we saw the Women's Suffrage Amendment in 1920, the 19th Amendment, making sure that women equally shared in citizenship. We saw the civil rights movements in the 60s and 70s ensure that the poll tax, which had been used to deny the promise of the 15th Amendment and preclude many, through the Jim Crow laws in the South, from actually exercising their right to vote. So with that amendment, we now made clear in our Constitution that everyone had a vote, everyone had a say, man or woman, black or white, rich or poor. And then, of course, in the 70s, we had the youth movement saying, look, we're being sent over to Vietnam to die. If we are old enough to serve in the military, we should be old enough to vote for the people who send us there. So these scholars elucidated the arc of constitutional progress that is literally written across the face of our national charter. They've created this scholarship. Groups like CAC litigated this scholarship in the Supreme Court. We were sometimes able to get the votes of Justices Scalia and Thomas, and sometimes more conservative justices like Chief Justice Roberts and Justice Kennedy. But I think most interesting to me, and what I want to talk about a little bit today, is that the more liberal justices were eager to embrace this originalist idea. We had at her Supreme Court confirmation hearing, then Judge Sotomayor describing the Constitution as immutable and explained that one must look to the words of the Constitution in interpreting it. This sounds like a textualist. Then Solicitor General Elena Kagan said something very similar at her own Supreme Court confirmation hearing, calling the Constitution an enduring document, one that should be interpreted by looking to the text, to history, to traditions, to precedent, certainly, and to the principles embodied in that precedent. But I think perhaps most strikingly, Justice Ruth Bader Ginsburg has emerged as a very powerful originalist herself on the court. And in fact, she described herself that way. She described herself as an originalist. Even Justice Stephen Breyer, who might be the justice least associated with looking to the text and history of the Constitution, has sometimes used the Constitution's text and history in his opinions, I think perhaps most notably in his decision in the recess appointments case and the Noel Canning case. But what is the difference between the originalism that is embraced by the more liberal justices in response, perhaps, to Justice Scalia's originalism and the one that he embraced? And I think the difference lies in something that Professor Amar talked about a little bit this morning, very briefly. And that's the embrace of the whole Constitution, that Constitution that I mentioned earlier that shows the arc of our nation's progress written into our founding charter. And Justice Scalia often, as Professor Amar noted this morning, was perhaps not as open to embracing those parts of the Constitution and privileged perhaps the 18th century Constitution, which I think is in itself in tension because the founders wrote in the amendment process into the Constitution, so clearly they didn't mean to privilege their work. And I think that what's important for the liberal legacy that Justice Scalia leaves us is that this embrace of originalism by justices like Ruth Bader Ginsburg allows progressives to root the arguments that are most central to the progressive movement directly in the text and history of the Constitution. I don't want to get into a big discussion of different interpretational methods, but there are a lot of lefty academics, one might say, who don't want to look at the text first or the text and history of the Constitution. Or there often are arguments that are sort of left to, well, this is the right thing to do. And that has been met with accusations from the right that I think might have a little bit of a point, that you can't just have it's the right thing to do and let the judges make it up as they go along as your judicial philosophy. So by embracing originalism and this scholarship that shows that the Constitution is inherently a progressive document, it allows the judges and justices who are writing these opinions to root the progressive results directly in the Constitution. And I think that's incredibly important. And if you look at recent cases that have come up before the Supreme Court, you can see how this is illustrated. If we think back to the first time that the Affordable Care Act was before the Supreme Court, we had a quintessential case of what does the Constitution mean when you have the federal government dealing with a national problem like healthcare reform. This could also come up in the context of climate change, something like that. And Justice Ginsburg, interestingly, in her separate opinion, brought out this piece of founding era history. She looked at when the Constitutional Convention was deciding how to write the powers of the federal government, particularly the Commerce Clause. Resolution 6 gave to the Committee of Detail, who was drafting, the idea that they wanted the federal government to have the power to address issues that were of national scope or when the states themselves were separately incompetent. So that's kind of the idea behind the Commerce Clause. When you have something that crosses interstate lines, something like climate change, we saw this in the Massachusetts versus EPA case, when you have pollution that flows over one state to another. And healthcare reform, where you have the interconnected markets. It's a national problem that requires a national solution. So Justice Ginsburg used this very originalist argument in support of Obamacare. We also have the affirmative action cases that have made their way up to the Supreme Court time and time again. And there, if you look at the text and history of the 14th Amendment, which has been used by those who are opposed to affirmative action to say that equal protection would not allow affirmative action, well, you look at the folks who wrote that language in the Reconstruction Congress, and they also passed many laws through the Freedmen's Bureau to ensure that there was equal opportunity for African Americans after the end of slavery. So the actual drafters of the 14th Amendment were really the originators of affirmative action. You look at cases like Citizens United, where a lot of folks on the left were very unhappy with the decision. Actually, I think the majority of Americans are critical of that ruling. Well, you go back to the founding and then up through the 17th Amendment, and you see originalist arguments for saying that the founders were very concerned with anything that gave them an improper dependence on anything other than the people themselves. You can say the same for reproductive choice. Ruth Bader Ginsburg has made very strong arguments for equal citizenship being the reason why women should be able to decide whether or not to have a child. There also is legislative history from the 14th Amendment that talks about how women under the slave power were not given the choice whether or not to bear a child or not, and the importance of being able to create your own family, a right that was denied to slave families. Over and over again, you see these important issues that are most important to progressives when you use Scalia's methodology of looking to the text and history of the Constitution, supporting progressive results. So that's something that he might not have liked as his legacy, but I think that it's something that is very real. And I think there's also something important that I'll close on that I think is an important part of this progressive originalist legacy of Justice Scalia's. So one thing that Scalia was notorious for was being friends with people from all ideological stripes. His friendship with Justice Ginsburg was well known. In fact, there is an opera that's called Scalia Ginsburg, and it's rather adorable about their friendship and their ideological jurisprudential debates. But I think what's important about having folks on the left and the right look at the Constitution's text and history is that we're talking about the same thing. we may disagree vehemently on whether or not the 14th Amendment's Equal Protection Clause mandates marriage equality or not. But at least we'll be talking about the same thing. And I think that's important for not just resolving the problems that our nation faces, but also for having civil discussion. And, you know, as you'll see on our next panel, Carrie Severino and I are frequently, Carrie is wonderful. We come from different sides of the ideological spectrum, but when we go on Fox News together and debate the issues, we come to very different conclusions, but at least we're on the same playing field. We both are arguing about the meaning of the Constitution and not whether the Constitution is something important or not. And as we've talked about multiple times today, it's incredibly important that Americans see the Constitution as something that belongs to them, that is something that they are a part of. And I think one of the beautiful things about looking at the whole Constitution, as progressive originalists do, is that it includes many of us who were excluded in the 18th century in the arc of constitutional progress. And it makes the document ours. And I think that being able to talk about it, being able to relate to it, is incredibly important. I think that's one of the legacies that Scalia will leave, and I'm glad that I got to talk about it with all of you, because that is another legacy of Scalia's, which is going out into the public and talking about the Constitution. You know, Omar raised his Constitution, said it was written briefly so that the average farmer could read it and understand it. And I loved that Justice Scalia was always able to go into the public and have a conversation about these incredibly important, complicated constitutional issues, but say, you're in this conversation with me. And so I think that by having this conference today, we're carrying on that legacy as well. Thank you.